Media is filling up again this week with articles about Lucy Letby, with headlines, in my view, that are designed to tell you or emotionally drive you as to what to think. For example, take this headline here that says, "Fury as Letby parents back freedom bid." Now, this has obviously come about because Lucy Letby has instructed new legal counsel, Mark MacDonald, to look at medical evidence and expert opinion to try again to take this case to the CCRC, which is the last route of appeal for her convictions. Now, this is important because juries can and do get it wrong. Take, for example, Andy Malkinson, who spent more than 17 years in prison for a crime that he did not commit, which, thanks to Appeal, the charity that commissioned DNA evidence that finally proved that he was innocent of this offence, but not before a jury had found him guilty, and he spent 17 years behind bars. But if you're an international viewer or you're not familiar with the Lucy Letby case, Lucy Letby was convicted in 2 separate trials for the murder of 7 babies and attempting to kill 7 others at the Countess of Chester Hospital between the years of 2015 and 2016. She's now serving 15 whole life sentences, meaning she'll spend the remainder of her natural life in prison, unless, of course, an appeal is successful. So in this video, I'd like to talk to you about balancing views and opinions. Now, I'll reiterate what I said in my previous video, that this is not intended to cause any upset or distress or indeed disrespect to anybody that was involved in the trial, directly or indirectly. But what I do find important is the way that headlines put these stories across to you and the way that you might be persuaded one way or another. For example, I always say if you sit through a criminal trial, by way of example, by the time you've heard the prosecution case, which you will hear first, you should be absolutely convinced that the accused is guilty if the prosecutor has done a fierce enough job of prosecuting the case. However, then you'll hear the defense case and any witnesses they choose to call, and interspersed in the prosecution case, the cross-examination of the prosecution witnesses. And after the defense case, you should be equally convinced that the person is not guilty of the offense charged. And you can break this down into even more nuance than that. For example, when you're hearing the evidence of live prosecution witnesses, for example, you should hear their first primary evidence and probably be convinced as to what they say. However, and conversely, when they are cross-examined by defense counsel, you may well be equally convinced that there's some doubt in what they are saying. The ideal scenario for a completely fair and unbiased justice system is that by the end of hearing all of the evidence of both prosecution and defense, you should be left in a situation where you have no real idea whether they are guilty or not. You should be convinced and then unconvinced, and then the jury go away to deliberate. In this case, the jury in the Lucy Letby trial heard complicated medical evidence for over 10 months, and they deliberated for 22 days on the evidence they heard. But what I'd like to talk to you and illustrate for you in this video is one particular part of the original trial and how you might be influenced as to what you think on a day-to-day basis, particularly when you're not a juror in any given case, but you are fed headlines and you're essentially told what to think. Let's take some examples, and then I'll also give you an idea as to what you may be able to do to better balance your views. Taking this one as an example, from The Mirror, it says, "Families fury as Lucy Letby's parents back campaigns to free killer nurse." Now, you'll hear subtle nuances, or not so subtle in some cases, in the headlines that I read to you here. Headline from The Sun reads, "She is guilty. Sick campaign to free Lucy Letby slammed by parents' lawyer as witness who helped jail her attacked by supporters." Another somewhat more neutral headline from the BBC, "Lucy changes legal team and plans new appeal." Another headline by The Standard, however, appears to support Lucy Letby, which reads, "Strong case for serial killer Lucy Letby's innocence, says new barrister." So you can hopefully see there how your thoughts and perhaps even your emotions might be swayed depending on the headlines you read. Now, what I'd like to do in this video is take one element of the original criminal trial and explain it to you in two different ways, which will hopefully allow you to see and experience how you might have different thoughts and perhaps even conclusions based on what I tell you. You might then get some insight as to just how difficult this would have been for the jury. But just before we get into that, if you want to understand any potential political bias of the articles and the newspapers that you've read, or just to get a better, more rounded or balanced understanding of any given article or topic, I'm very proud to introduce you to Ground News, which is both an app and a website which collates news sources from around the world and gives you additional context. For example, any potential political bias that I've mentioned in this video, a credibility score against each article that you read, and even an indication as to ownership. By bringing together various news sources from around the world and across the political spectrum, it allows you, the reader, to compare and contrast various views to avoid confirming any previous biases or pushing you or directing you as to what to think. Using the broad news topic of Lucy Letby by way of an example, I can either search for Lucy Letby in the search bar or by searching for an article URL that I've already read. Let's take this article by way of example. Families hit out at Letby Innocent's speculation. First of all, you can see at a glance the bullet points that you should take away from neutral news outlets, those that lean left or a little bit more conservative. More about that in a minute. But then you can see the different headlines focusing on different parts of the story. The Journal, for example, focusing on the UK inquiry into the case, begins hearing evidence. The Independent, on the other hand, focusing on the fact that the hospitals were said to have ignored pleas to call the police over the deaths of the babies, whereas the Irish Independent focused on the speculation as to Lucy Letby's guilt being devastating for the families, and that the possibility of future appeals has been upsetting for them. A contrasting headline highlights that whilst the investigation has been launched, it has been criticised in advance following doubts about Lucy Letby's guilt. But another interesting thing about this story is that out of all of the reported sources, only one of them is conservative. That means if you only read conservative outlets, you might miss this story altogether. This is precisely why Ground News has a blind spot feature, which shows readers stories reported from either end of the political spectrum, which you might otherwise miss out on due to algorithms that are completely out of your control. Of course, I get you a discount, which is 40% off unlimited access to the world's news, using the link that's on screen or the QR code, or the link in the description, which is ground.news/BBB. And so the next time you want to check whether what you're reading is politically biased or you just want another opinion, check out Ground News and you'll have the full picture. So now I'm going to talk to you about one particular aspect of the prosecution evidence in the Lucy Letby trial. That is the expert evidence of Dr. Evans. I'm going to give you a couple of different ways of thinking about it so that you can just get the smallest glimpse into just how difficult this might have been for the jury. Now, I appreciate this is going to be a few minutes of me talking to you as opposed to the 10 months that the jury sat through this evidence and then took 22 days to deliberate. Now, this medical evidence was the subject of an application to exclude it, but more about that in a moment. So Dr. Evans was tasked not only with the investigation before Lucy Letby was charged with these offences, but also as an expert evidence in court as well. So first of all, in support of Dr. Evans' evidence, I might say to you that Dr. Evans is one of the leading experts and you should absolutely trust his expertise. He qualified as a medical practitioner in 1971, some 44 years before these incidents took place. He trained as a paediatrician in Swansea and then in Cardiff and Liverpool. Each of these phases of training involved specific training in neonatology and working in a neonatal unit, and he was appointed a full-time clinical consultant paediatrician in Swansea in 1980, some 35 years a consultant before these incidents took place. He held this position as a clinical consultant paediatrician in Swansea for some 29 years. During the 1980s, he became involved in the development of newborn services and intensive care service for babies. He was responsible for setting up, supervising and leading the neonatal intensive care unit in Swansea from his appointment, developing intensive care services from scratch. His experience, he said, was very much hands-on. In 1990, in Swansea, the Health Board built a new children's department which included a new neonatal unit which he helped to design. His operational and managerial roles involved serving as a clinical director of paediatrics and neonatology in Swansea between 1992 and 1997, and between 2004 and 2008. In his evidence, he said that Swansea was one of the bigger units in South Wales, and it covered the area of the whole of the south of the west of Wales over that time. He had training in neonatology. When he arrived, there was no specialist neonatology services at the hospital, and it was just a question of getting on with it. His team had to deal with all the babies in the catchment area. The only babies that were sent elsewhere were those requiring surgery, who went to Cardiff, or those requiring cardiac care, who went to Bristol. So all of the tiny babies who required intensive care were under his care or the care of his colleagues in Swansea from 1980 onwards. So you can very clearly see from this portion of the judgment a summary of the experience and expertise of Dr. Evans is second to none. He is arguably one of the longest serving clinical consultant paediatricians that could have investigated this case and given evidence on it in court. However, whilst Dr. Evans' experience and expertise was not disputed in a general sense, the defence did make an application to the court in the absence of the jury to exclude his evidence. And this also became one of the grounds of appeal, in that they said the court should have granted that application and excluded his evidence. However, this application to exclude his evidence was only made 3 months into the trial, after Dr. Evans had already given evidence on counts 1 to 9 on the indictment. The substance of the defence application to exclude Dr. Evans' evidence was essentially an attack upon his credibility, which the defence said was fundamental to the character of his evidence. The defence relied upon the comments of Lord Justice Peter Jackson, which were heavily critical of Dr. Evans, in an unrelated application for permission to appeal to the Court of Appeal Civil Division in a care proceedings case. In that application, Lord Justice Peter Jackson described the report written by Dr. Evans as worthless. Commenting on Dr. Evans' report, Lord Justice Jackson said, "Dr. Evans makes no effort to provide a balanced opinion. He either knows what his professional colleagues have concluded and disregards it, or is not taken steps to inform himself of their views. Either approach amounts to a breach of proper professional conduct. No attempt has been made to engage with the full range of medical information or the powerful contradictory indicators. Instead, the report has the hallmarks of an exercise in working out an explanation that exculpates the applicants. It ends with tendentious and partisan expressions of opinion that are outside Dr. Evans' professional competence and have no place in a reputable expert report." After the defence application to exclude Dr. Evans' evidence was refused, of course he was heavily cross-examined on all of these points to do with credibility and involvement in the case, and doubtless submissions were made to the jury before they went off for deliberations. It was repeatedly put to Dr. Evans that he took a one-sided approach to this case, that he was reaching for things to support the allegations rather than reflecting on the true facts, that he was not being independent, that he was touting for the role as investigator and expert on the case. The jury were told that he sent an email to the National Crime Agency in May 2017. This was before his involvement with the police. He said, "I've read about the high rate of babies in Chester and that the police are investigating. If Chester Police had no one in mind, I'd be interested to help. Sounds like my kind of case." The defence barrister said this was putting yourself forward, touting for the job. Furthermore, the defence argued that Dr. Evans had an unusual involvement with the investigation into the events of the hospital, with the consequence that he'd acted as an investigator rather than an independent expert. The defence argued that he'd constructed theories to support the allegations on the indictment and had given evidence in a manner that was improperly subjective, emotive, dogmatic, and biased. So hopefully you can get just some idea of the fiercely competing arguments for and against Dr. Evans' evidence. On the one hand, he's one of the longest serving, most qualified and experienced consultant paediatricians around. On the other hand, strong arguments made as to his credibility and impartiality and his role in this case. But ultimately, it should be said that the court considered all of these things, particularly at the Court of Appeal with the application for permission to appeal, on the ground that his evidence should have been excluded. The court did conclude, it should be said, that Dr. Evans was highly qualified and suitable, and that it was not arguable that he lacked the necessary expertise to give evidence in this case. And it should have, as it was, been left to the jury to decide as to what weight they placed upon his evidence. It should also be said that there was a huge volume of medical terminology and complexities within this case that the jury simply would not have been able to understand without an expert such as Dr. Evans. So I understand there's lots of discussion online, there is lots of speculation, there's lots of curiosity by many people who were not at the trial, not least of which for the 10 months that it was running. And this judgment alone from the Court of Appeal was 58 pages long and over 200 paragraphs of discussion. So if you want to take a look at that judgment from the Court of Appeal, it might give you more idea as to the things that I've discussed in this video. But again, this video was not intended to upset anybody, just to give you an idea of how very differently either an expert or a piece of evidence can be cast in view of the jury to draw different conclusions. And that is the advocate's job. So when you hear an advocate, a barrister or an advocate elsewhere, arguing for one side or another, just remember, they don't necessarily agree with those arguments. They are making the best argument that they possibly can for whom they are making those arguments. And so when you hear both arguments, you may have mixed feelings about that, and that's perfectly fine. The whole idea of the balance in this justice system is to hear both sides fiercely and without fear or favour. It is then for the juror to go away, deliberate and consider the evidence. And it's the jury that makes the finding of fact in these cases. So I hope you found that interesting. Please do leave me your thoughts and comments below. Remember to subscribe if you'd like more of this content. And as always, thank you for watching.